asking for justice for Michael Brown. He got his justice. You know, and it's a photo of him dead in the street. And she's constantly was doing stuff like that, and we pray for Officer Wilson. And you know, when she was in the grand jury, she basically denied that she was like a stooge for Officer Wilson. She was just there to tell the truth. You know, and she was involved in a Facebook page that she started 10 days after the shooting that purportedly was there to support law enforcement officers and first responders in Ferguson, and had nothing to do with Officer Wilson. They were raising money in a kind of a crowdsourced fashion. And in the end, they donated all the money to the Officer Wilson Trust Fund. So, you know, I mean, this was all easily obtainable.
Could she be charged with perjury?
She should be charged with perjury. She lied to the cops. That's making false statements. The first time, September 11th, when she sat down and she spoke with the FBI and the Department of Justice, she lied to them. The first time they put her in the state grand jury, she lied. The second time, she admitted she lied the first time and then lied again. So she's got, yeah, she should. You know, and it's one of these things where, yes, she has said that she she's been diagnosed as being bipolar and that she has bouts of mania. But, you know, she insinuated herself into a case of national importance and spun out a story that was totally untrue. And do you walk away from that without some sort of, you know, the government just saying, oh, that's fine. But next time something like this happens, if you're a lunatic and you want to come forward and create a story that's going to back up the cops, come on in. We're happy to have you.
But that's the bigger question in my mind. It's not what she did, but what prosecutors did. Because either they were totally inept in one of, as you say, one of the biggest cases in recent times of national attention, or they knew or suspected that she was lying and didn't care, which was even worse.
If you're a prosecutor and you know that someone's going to come into a grand jury and lie, you can't really allow them to do that. That's called creating a perjury trap.
Can a new grand jury be convened based on this?
I don't know. I mean, I think that's probably a fairly tough thing to do.
And you spoke to her?
Yes. I mean, she would not talk to us before the story came out. We published the story on Monday morning. Yesterday, I corresponded with her in which she admitted that, yes, in fact, she was witness 40, and she expressed concerns for the safety of her 3 minor children, and she's trying to erase her social media presence. And then I had she wanted to have a conversation off the record, which we had a lengthy conversation off the record, and hopefully we'll maybe try to see if she'll want to move some of that on the record.
Well, and of course, witness 40 was the importance of her testimony was that she and there's at least another witness, as I recall, witness 10, who were the ones who said that Brown charged at police officer Wilson. And so obviously if her testimony is impugned, then the issue becomes, what about this other witness? And I want to turn to MSNBC's Lawrence O'Donnell. Late last month, he dissected the credibility of that other witness, witness 10.
Witness number 10 was working in the neighborhood, and he begins his story to the police with, I seen the 2 young guys walking down the street on the same sidewalk that I was on. 6 weeks later, witness number 10 testified to the grand jury and changed his story about where Michael Brown was walking. He said under oath to the grand jury, I seen Mike Brown and his friend walking down the street closer to the curb, not on the sidewalk. That is the kind of thing the district attorney was complaining about last night. Witnesses changing their stories to fit the publicly known facts. Here is why witness number 10 was the most important witness to appear in Darren Wilson's defense. This is what he described Michael Brown doing when Officer Wilson got out of the car and chased him. Michael Brown stopped. He did turn. He did some sort of body gesture. I'm not sure what it was, but I know it was a body gesture. I could say for sure he never put his hands up after he did his body gesture. He ran towards the officer full charge. So there's witness number 10 saying the magic words. He never put his hands up, and he ran towards the officer full charge. In the grand jury, when the prosecutor asked witness number 10 to describe what he called a body gesture, he said, "I can't say for sure what sort of body gesture. I cannot fully recall. All I know is it was not in a surrendering motion of I'm surrendering, putting my hands up or anything. I'm not sure if it was like a shoulder shrug or him pulling his pants up. I'm not sure." So there's the district attorney's favorite witness, the only one he quoted last night, saying, "I cannot fully recall. I'm not sure. I'm not sure," within the body of an answer in which the only thing he's absolutely sure of is that Michael Brown did not do a surrendering motion. In a real courtroom, when a witness begins his answer with, "I can't say for sure," and then in the body of his answer he says, "I cannot recall fully," and then says, "I am not sure" twice within that same answer, that witness observation does not survive cross-examination. But there was no cross-examination in the grand jury room.
That was Lawrence O'Donnell on his show on MSNBC, Last Word with Lawrence O'Donnell, and he went on from there. His final point about juror number 10 is that when he was asked by the police how far away he was, he said about 100 yards, a football field away. When he goes into the grand jury, he says something like 50 yards. He cuts it in half, or 50 to 75 yards. Can he see? Does he wear glasses? None of those questions, because this isn't a trial. This is a grand jury. Juan.
Yeah, well, in light of this, Bill, your sense of, because obviously there's still a federal investigation going on, and this kind of dissecting of these witnesses and the testimony that led the grand jury to decide there was no reason to indict will certainly catch the attention, hopefully, of the federal investigators.
Yeah, I would think that I have hopes that the investigation that they would do would be a lot more thorough than the local law enforcement agencies have proven to be capable of undertaking. I would assume that if someone says they were there, there's going to be a good attempt of trying to figure out, in fact, whether they were there. Did they have their cell phone? Did it ping off of a cell phone tower? You know, anything. Is their car on any of the surveillance video outside some of these buildings? I mean, the witness 40, McElroy, you know, conveniently, when she took this, 30-mile drive up there, she left her cell phone at home. You know, I mean, there's so simple ways to just go get her cell phone bills. You know, there's like a 6 or 7 hour time. If she placed one, she doesn't have a landline. If she placed one phone call off of her cell phone, you pick it up off of it, pinged off of a tower, and you'll know she was nowhere near Ferguson at the time. You know, and the other thing is that when she testified the first time in the grand jury, it was one day after the St. Louis Post-Dispatch published a lengthy story that detailed exactly what Darren Wilson told police about his version of events. And if you look at that story and you look at her testimony, you wouldn't be able to tell the two apart. So you get a good idea where she came up with all the facts.
Well, William Bestone, we thank you so much for your reporting. Of course, we'll continue to follow this. And what does this mean for a grand jury? Could there be another grand jury? What does this mean for the prosecutor, for Bob McCullough? William Bestone is editor of The Smoking Gun and lead author of the new article, Witness 40, Exposing a Fraud in Ferguson. We'll link to it at democracynow.org. When we come back, what's happened to James Risen, the Pulitzer Prize-winning journalist for the